of order.
Thanks. Appreciate it.
Okay, please be seated, folks. Yes.
We need to do this on the record, see what's going on.
All right, let me see counsel at the bench for a moment, please.
Dave.
Okay. Do we need a sidebar first or not? Okay, thank you. Let's go ahead and bring our jury back in. Mr. Mosley, do you need any, the podium turns if you need it. Do you need the overhead on? Can you what? Sure. You can grab more than one if you want. You want one over your legs too?
All right, very good.
Sue, I can give you my robe too. It's too hot for me.
There you go.
Please be seated. Folks, let me inquire because my court reporter just mentioned it or showed me. Are any of you freezing? Do we need to try and raise the temperature a little bit? You are freezing? Okay, 2 of you are. All right, we've got a couple of shawls and we'll see what we can do about the temperature, but it's a big building to cool down, okay? Jeff, would you just put those on the rail in case somebody needs them?
Put it one more time.
Thanks.
I got it. I got it.
Mr. Mosley,
Yes, Your Honor.
closing?
Yes, Your Honor. Ladies and gentlemen, again, thank you for being here. And I want to talk to you about what I think the evidence has shown in this case. We told you in the beginning that this case was going to be a case built on circumstantial evidence, that the state was going to give you a lot of stuff to try and prove what they didn't know or what they don't have. In this case, you're going to hear a lot from witnesses, you heard a lot from witnesses in this case about cars going in and out of neighborhoods, cell phones, people claiming to be experts talking about cell phone towers, Meg Hughes talking about GPS monitors, but you don't hear anybody placing Mr. Okafor in the house at 503 Bernardino Drive. I told you before that the best witnesses in this case is Brianna Campos and Remington Campos. The one thing you can be sure of with Brianna Campos and Remington Campos is that their statements are unequivocal. They tell you what they saw, unslanted. And without a doubt, as I defend Mr. Okafor, we recognize how horrific this crime was, and we recognize how bad it is for that family. We see them every day in court. We have sympathy for them too, so don't confuse us with this argument. We understand who they are and what their pain must be. But this case is about evidence in this courtroom. It's not about miracles, not about plans. It's about what these people can prove in this case. The court's going to tell you with the jury instructions what their obligations are. Going to tell them what elements they have to prove in this case. They have to prove beyond and to the exclusion of all reasonable doubt. They can ask you to make quantum leaps and say, look, fill in the gap for me because this is a horrific crime. They can ask you to do that. They have to prove their case. What we know in this case is Brianna Campos had previously identified Bessman Okafor on May 9th. She knew what he looked like. She knew how big he was. If you recall on the stand when she testified, I asked her, how did he look when you saw him in May? She said he was big. He was big, like he had been working out. I asked her, how did the person look that pulled you out of the room that morning, September 10th? She said, lanky, lacking mass, and a fresh haircut, a very low fresh haircut with a fresh edge. See, Brianna is detailed like that. That's what happened to Mr. Okafor on May 9th, because she was detailed like that. On May 9th, 2012, Brianna did this. She told law enforcement the person who broke in his house had slashes in his eyebrow. He was big. And she identified him. So when law enforcement disregards what Ms. Campos says, that becomes an issue. Because now they are putting on evidence contrary to their best witness. She says who the person was in the house, and they want to ignore it. And this is why I told you earlier that law enforcement had decided who they wanted to be guilty in this case. And they decided this way. When Detective Mareshi got involved in this case, he went to the hospital and he spoke to both Miranda Campos and Remington Campos. And he, at the time, wasn't sure what was going on in this case. He inquired and someone told him, maybe Brianna or someone else, told him that the same house had been broken into back on May 9th, 2012. They realized at that time that Nolan Bernard was still in custody of the Orange County Jail, and that Bessman Okafor had bonded out and was on GPS monitor. What they did not know at that time was that Nolan Bernard, and these are relationships, Nolan Bernard was the cousin of Emmanuel Wallace. He was also somewhat a brother-in-law to Donnell Godfrey. This is what law enforcement ignored. They immediately thought this was all about Bessman Okafor. This was about Nolan Bernard. These were his people. Godfrey and Emmanuel Wallace were Nolan Bernard's people. Now, let's link this up. Because the truth is, I don't have to say this, but the truth is, on September 10th, around 5:15, 5:20 in the morning, it's dark, it's quiet. They're sleeping. Brianna Campos is in her room, asleep. She hears some noise in the house. She thinks she hears noise in the living room. She gets up. She puts on some clothes. As she's walking out of her bedroom to the living room, somebody grabs her. This tall, lanky person with this fresh haircut. Tells her to lay down on the ground, on the floor. When she gets there, she sees Alex there, her brother, her friend. While she's there, she hears rumbling in her brother's room, Remington's room. She looks up, she sees Remington walking towards her, and a person puts him down on the floor. But Remington says, I see the whole room. I see no one in that room but a skinny person with long dreads and a long rifle. And a guy who's walking me out with a gun to my back. We know that was Donnell Godfrey. We know that was Emmanuel Wallace. There's no dispute about that. The eyewitnesses told you that. They told you that. Now, the state in their case, that was not enough. They wanted to make another case against someone else. And we all know you have enough money and enough resources, you can make almost anything happen. You can make a case. Here we go. After they get this information from Remington and Brianna, they ignore Brianna's description, starting on Bessman Okafor. They started going and get cell phones. Cell phones that Detective Michaels told you that he knew himself that at least 4 people used the same phone. Brent, Trent, Bessman, Candace, and 5, and sometimes Emmanuel Wallace. He testified to that right there. The same phone. Meg Hughes, you saw her again this morning. And it's sometimes difficult for her to be straightforward, as you can see. She didn't want to tell us this morning, as she told us previously in sworn testimony, that she had contacted this man on the phone and heard that base unit beeping as if he wasn't there. But she knew he was home because she'd heard it. She knew he was home because she had heard it. Now, court's going to tell you that when you weigh the evidence, you can look at things like that, how people hedge and making statements, how they don't want to tell the truth, they're kind of reluctant to tell the truth. You know, I asked a couple of people questions up there, and they were like, didn't want to say it, give them a hard time. Like I asked Ms. Hughes about that one statement today, had it happened before. She didn't want to say that. Detective Bareshi, he is like a manager, really doesn't know any direct facts. He comes to testify to you about what people have told him, what this law enforcement person has told him, that person has told him. He can't really tell you what happened. That is not his job. He's kind of managing folks and trying to make his case. But when you think about it, Karen, I believe Lobbygood, CST, came in and testified. We processed the home. And we did not find any latents, fingerprints. We didn't find any DNA. We didn't find anything in the house that would connect Bessman Okafor to being in the house. They're a CST person. Then he brought Christine Murphy in, who says they found some gun clips. But those gun clips were not in Bessman Okafor's house. Was not in his mother's house. They were in Emmanuel Wallace's house. Again, there's no mystery that Emmanuel Wallace was in this. Remington Campos told us who he saw. But again, if we throw enough mud on the wall, sometimes people hope it stick. If we rub the blueberry pie on the cat's face, sometimes people believe that the cat is guilty. Now, I will tell you this. There is just no way to ignore that description that Brianna Campos gave. No way. You all had the opportunity to see Nestle Cicerone walk from that door across this floor. Okay? You all saw that. Think about this for a moment. If you believe four men were involved in this scenario, think about who fits the description that Brianna Campos gave. Donna Godfrey, tall, big, and husky. Emmanuel Wallace, skinny and long dreads. Bessman Okafor, muscular like a muscle builder. Nestle Cicerone, lanky, low haircut, always. He said it right there. My haircut's always this way. Why? did law enforcement not question him after Ms. Campos gave that kind of a description? That was not some willy-nilly description. She gave great detail in what she had to deal with. And as you can see from the state's photograph of Mr. Okafor at the time he was arrested, 1 day later, his hair couldn't have grown that fast. A fresh haircut, a fine, neat edge, it is impossible for it to grow that fast. This is a few hours later, not even a full day. And you heard his sister said he's 220 plus pounds, which is consistent with Ms. Campos. Sister Ron, 6 feet tall, he said to you, and he hedged a little bit, again, you can weigh that and determine your case. How much you weigh, Mr. Sister Ron? Well, I weigh somewhere between 180, 185. Remember, I asked, so you're telling us that you were out on the road by yourself at 5:20 in the morning and you had no idea why you were there? No idea why you were there. And you were sitting somewhere by yourself, right? Yes. Could anyone account for what you were doing during that 20 minutes? He said no. He said no. And based on his own testimony, he put himself in the neighborhood. He put himself in the neighborhood right down from the house. We don't make that up. Again, we get that from the state's best witness, who has a record of testifying and identifying Bessman Okafor. Now, they talk about all these cars going in and out of the neighborhood. They saw a car at a gas station. Allegedly, Sharia Gordon was in that vehicle. Went to a store, paid some gas, pregnant woman. She says a lot. She says he was her boyfriend, father of her children. He told her to come with him and told her to sit on the side of the road. Again, ladies and gentlemen, she doesn't know why she's there. And you can evaluate these folks for telling the truth. How many people get up 4 o'clock in the morning and go sit on the side of the road and don't know why they're sitting inside the road? Both her and Nestle claimed they didn't know why they were sitting inside the road, because they're liars. And you get a chance to weigh that in your evaluation of this case. Sharia Gordon told you that she had at least given Detective Mareshi 5 statements prior to deciding that she was going to say Ms. Okafor had something to do with this. You tell 1 lie, maybe you don't consider that person a liar. You tell 2 lies, maybe you consider that person not so trustworthy. You tell 3 lies, you start to think that person might be a liar. You tell 4 lies, you know that person is definitely a liar. You tell 5 lies, you know you can't trust that person. And they want you to trust that person. Nessa Cicerone tells that same story. He gets up out of his bed. He goes somewhere in the middle of the morning. He doesn't know where he's going. And he's just going there. The important thing for you to know is that the court's going to tell you that you can even consider the fact that these people are in plea agreements. It's like paid testimony. I pay you to say what I want you to say. I give you this, you say this. And what's important about that If you recall, when I was speaking to Sherelle Gordon, she said, well, I said, well, when did you finally tell them what they wanted to know? Well, Detective Maresha gave me the specifics. If that's not telling a person what you want them to say, I don't know what is. I don't know what is. This is a serious case, ladies and gentlemen. This is not the typical run-of-the-mill circumstantial evidence case where you can just say, well, you know what, if I made a mistake, so what? Not that kind of case. Not that kind of case. You made a promise. And you're chosen on this jury. You promised this court you'll follow the law. And you promised us that you will listen to the law, and that you promised us that you will make the state prove its case beyond and to the exclusion of every reasonable doubt. Not part of it, not a little bit of it, not to cast aspersions or make innuendo, but to provide you the evidence that you need to come to a proper conclusion if they're going to ask you to do something. We told you from the beginning that we didn't have to do anything, that my client did not have to take the stand, and that you promised us that you would not hold it against us. You said you understood it. And you said that no matter what an individual said on this jury, that if you believed in our case, you would stand your ground. You would fight for what's right. I'm going to hold you to that. I'm going to hold you to it. Because, again, I recognize how emotional this case is. I'm a human being, like all of you. I know what it means to our family. I do. But if this process is to ever work, this is the greatest test. Because you have to deal with what really is out there in terms of the pain. But you also have this obligation here to follow the law. And when you leave this place, you want to feel good about what you've done, the decision you made. You want to make sure you didn't make it on emotion, but you made it on fact. You want to leave here and say, well, you know what? It's made a gaping hole in that case, but I made an emotional decision. The gaping hole, ladies and gentlemen, is a house. It's a house. They can't put Bessman Okafor in that house. They can't put a gun in his hand. They can't put fingerprints in the house. They can't do that. But they can get folks to come here and say little things and try and make you believe. Now, text messages. I'm going to be straightforward and honest with you. There are some things Faye's talking about are troubling. Extremely troubling. But again, you have to tie those things up to what they really have. They want you to say, well, somebody was thinking about this on this day. Some 16 days before anything happened in this case. Because somebody was thinking about something 16 days before, they must have done something. How many times have you thought about something and changed your mind? How many times you thought about, well, I should do this, I should go there, and you changed your mind? How many times? And not always do we have the best friends. Because sometimes people will paint a picture of you because you have bad friends. Because you know the Donnell Godfreys of the world, and the Emmanuel Wildeses of the world, and the Nolan Bernards of the world. because you have bad friends and somebody's done something that no one knows about, they assume that you've done it. And they assume because they don't have any direct evidence that you've done it. But because you just happen to be associated with those people, you must have done it. And that's not what this case is about. This case is about making them prove that you did it or he did it. I think one thing about trial work is that you have to search for credibility in the final analysis. You have to really tell folks what the weaknesses are and the strengths are if you want them to believe you. You want them to really search their innermost conscience to find the right thing to do. I'm not saying my client is the best person in the world. I had you promise in jury selection that just because he had been previously convicted of something, that you can give him a fair trial. You said you could. I asked you point blank, if you find that he was convicted of something, could you still give him a fair trial? Each of you said you could. You said you could. I want you to think about not about Mr. Okafor right now. I want you to think about this great system of ours that this court reminded you of on the first day. He said this system that we live in and that we participate in is the greatest system in the world because we allow our citizens to determine what happens to us in these criminal proceedings. I want you to think about that for a moment. And I want you to think about that because of this. Sometimes we have a tendency to say, you know what? Politically, the right thing to do is find him guilty. Because everybody thinks he's guilty. Everybody's told us he's guilty. But when you love and respect the system, you then work harder to find the truth. Then you say, do I give it all up for one case? Do I throw it all out the window for one case? Or do I really believe in what Americans have talked about for so long and been so proud of for so long, this jury process? If you don't know, ladies and gentlemen, you don't know. If you're guessing, you are guessing. I'm not going to have you to guess. I'm asking you not to guess. I'm asking you to demand that they prove their case. State made promises to you. An opening statement. Mr. Auburn walked around for an hour to 7 minutes. Made promises to you in the opening case. He told you that he was going to prove to you that Bessman Okafor shot these 3 people with a revolver. Here we are. I want you to think about it for just one moment. Have you heard one witness tell you that one witness. He had law enforcement talk about a lot of stuff, but not one witness. He told you that he's absolutely going to prove that a revolver was used. Now I want you to think back to Christine Murphy. She said, well, you know, I believe that all 3 of these bullets came from one gun. She said a .38. And I asked her, I said, well, Ms. Murphy, can you tell me whether those bullets could have come from a semi-automatic? And she said, yes. Not my witness, his witness. So already what he's promised you, they haven't met. The one thing I say to you is that Detective Mareshi, I respect him. Known him for a long time. But remember this. When he was on the stand and he was commenting about these vehicles, these cars going in and out the neighborhood, I said to Detective Mareshi, Detective, can you tell me whether you can identify anybody of those vehicles? He's not at the scene, he's not at the house, doesn't have a gun. No guns found at his house. No guns found at his mother's house. No clips found at his house. No bullets found at his house. Nothing. Nothing. Reasonable doubt. It's not got reasonable doubt. I'm not naive. I know it's a tough case for you. But, again, it's their obligation to prove the case, to give you the evidence you need in order for them to meet their burden. They have to prove each and every element beyond to the exclusion of reasonable doubt. Mr. Williams talked to you about what they had to prove. They had to prove premeditation, and if you believed that Mr. Okafor did this based on evidence, then because of the way they claim this crime occurred, might be premeditation. But the problem is this. They can't prove Mr. Okafor did this. Again, because they just jumped to conclusions from the very beginning. And I guarantee you, Nestle, Cicerone is laughing all the way to the bank. He got away with one. Guarantee you. Remember I asked Nestle Cicerone on the stand, I said, Nestle, you've known Mr. Okafor for a long time, right? Yes. Have you ever known him to be violent? Think of what he said. No. I've never known to be violent. Never known to be violent. I'm just saying. Sometimes people do things for you that they think you need and that you want, that you don't ask them for. I don't know what Nessie was doing out there at 5 o'clock in the morning if he was innocent like he's claiming to be. But I would not believe that a grown, intelligent man goes anywhere at 5 o'clock in the morning and not ask questions, or unless he has his own agenda. I don't know anybody that would get up 5:30 in the morning, go anywhere, just go. Unless they have an agenda. They're part of some kind of plan or some kind of scheme. But the state says that Nessie Cicerone didn't have an idea what he was doing. That's their witness. Can you believe that? No, you don't believe that. I'm taking you for granted. They're trying to get you to make decisions because it's an emotional case. You don't believe that. Some of you stated that the state, you understood the state had to prove their case. I'm just simply asking you to make sure that they do it. If they can, let them do it. Don't stretch for them. Don't reach for them. Make them do it. Can you trust everything they've done so far in this case? Absolutely not. Not. Especially with people like Cicerone saying he didn't know why he was out there on the street. Especially when the state goes contrary to their own eyewitnesses. Excuse me. I'm about to close. Just ask that you remember this too. Ask Cicerone. Again, I believe this case rests on Brianna Campos, because Brianna tells us a whole lot that they ignored. She said the man came in there and said, "Is this the place that was robbed previously?" Certainly. If Bessman Okafor was the person there, he would have known it. Remember that litany of questions I asked Brianna Campos? And Brianna probably was confused when I asked those questions. I said, "Brianna, did you paint your house? Did you change your house? Did you do something differently?" Because that May 9th robbery took place in broad daylight. So if Bessman Okafor was in that house, he would have known the house. He wouldn't have had to ask that question. I asked her, "Did you do anything different to your house?" And the reason I asked that question is I wanted to find out why they think he would ask that question if he had been there before. This cell phone stuff. Let's really interesting watching the dynamics between Mr. Ilnaka and the cell phone person. He was put on as an expert. You all witnessed it. Mr. Ilnaka asked him questions. He couldn't answer the questions. Mr. Ilnaka would tell him a little bit, and he still couldn't answer the questions. Ultimately, it came down to this. He wanted you to believe that these phone calls were pinging off of a tower closest to the crime scene. Well, it came out during testimony that the closest tower to the crime scene, none of these phones pinged off of it. None. It's a lot of stuff. A lot of stuff. But after all that comes in, do you know any more today than you knew the first day you sat about what happened in that house? You don't. Ladies and gentlemen, I'm going to ask you to return a verdict of not guilty based on the way this case was presented to you and based on the facts you have. Because this case is based on what people want you to think. They want you to connect dots that are not there. They want you to find facts they can't prove. They're going to come and tell you, well, this is, open statement. This is overwhelming evidence. This is insurmountable evidence. Everybody's thinking that, well, they're going to have something to prove what happened in the house. Didn't happen. It did not happen. If you find they did not prove the case, then the right thing to do for everybody in this system is to return a verdict of not guilty. Thank you very much.
Thank you. State.
Bessman Okafor, along with his two friends, into 503 Bernardino Drive for one purpose, and one purpose only, and that was to kill the witnesses who were going to testify the very next day against Mr. Okafor for the home invasion robbery that he had committed 4 months ago. And there was an overwhelming amount of evidence that you heard to prove that fact. I listened very carefully to Mr. Mosley's closing argument, and there were a number of things he never even spoke about. All he tried to talk about was that Vienna Campos somehow, in his version of events, got a perfect view of the person that got her out of the room. And that perfect view that she got might not have been the description of Bessman Okafor. Well, let's remember what Brianna Campos said. She's asleep in bed. A few minutes after 5 o'clock, she is woken up by some sound. She tries to put on some shorts, her door flies open, in a darkened bedroom, well before daylight. A man comes in with 2 T-shirts covering everything except his eyes, points a gun at her, and tells her not to look at her. Tells her don't look around. Forces her out of her bedroom, is standing behind her. That's the last she ever saw him. She saw he was wearing long sleeves, baggy clothes. That's the best description she could give. She couldn't even tell you his race. That's this wonderful view she had and this wonderful description she could give you. That's the best she could do. She's a guy with, all she could see is his eyes, not even his race. She got a little bit of his hair, I guess. It looked like under the T-shirt, it looked like a fade or something like that. He was in fresh cut. And that's the description she could give, that he was wearing long sleeves, baggy clothes, and that's the description she could give. And Mr. Mosley is going from that to say, well, that's, he's not whiny. That's it. Let's look at what the evidence did show about Mr. Okafor that Mr. Mosley never even spoke about. What about the home confinement records? Mr. Williams showed you the home confinement records. I won't show them to you again, showing that Okafor was out of the house for an hour and 6 minutes, exactly when the murder happened. From 4:40 a.m. until 5:46 a.m. How did that happen? And he was also out of the house for, I believe it was 19 minutes earlier than that evening, from I believe it was about 3:50 to about 4:09 or something like that. How did that happen? And he was also out of the house for, I think it was 48 minutes earlier than that. You also heard from everyone that there's this loud beeping noise that happens from the base unit when you're out of range, when your ankle monitor is out of range from the base unit. So how did all this happen? Is this just a coincidence? If Mr. Okafor's ankle monitor is not connecting to the base unit, but he's out of the house, there's this loud beeping that would be going on constantly, and he's what? Sitting out in the backyard while all this is happening, and it just so happens that this is during the time of the murder, from 4:40 to 5:46. Mr. Mosley, give any explanation of that? And it's not just the home confinement. And let me just talk about something else with that home confinement. You heard that, the first couple of days, which you might expect in setting this thing up, there were some problems. There were some problems with the electrical system or the phone system that got corrected. After that, there were no problems. The home confinement system was fine. And even if there were some problems with the phone being unplugged or whatever, that did not show up as a curfew violation. You heard that from Chris Gould when he testified. What shows up as a curfew violation. It says curfew on...
Excuse me. Objection. Approach, please.
Let me change colors. I don't like that color. Look at all of this the night of the murder. This is September 10th, 2012, 2:38:56 a.m. to 3:27:27 a.m., 48 minutes. That base unit is beeping away in the house. This loud, annoying beep. Okafor comes back at 3:27, then at 3:49:27. He's out of the house again for 19 minutes and 1 second. Loud, annoying beep in the house. And then at 4:43 a.m. until 5:46:59 a.m. for 1 hour, 6 minutes, and 16 seconds. Again, he's out of the house, loud, annoying beep. Remember the time that everything happened. We know from Justin Fleck. Let's focus first on this, the one from 3:49:27 to 4:08:28. We heard from Justin Fleck. This is Mr. Okafor's phone records. Remember, the yellow is Mr. Okafor, 407-221-7378. And what do we have down here? At 3:52 a.m., exactly when he's out of the house, what the home confinement records show, that he was out of the house beginning at 3:49, and here we have at 3:52, he's making an outgoing call to Sharia Gordon. That's what the phone records say. And he's hitting off a cell tower away from his house, which is over here. And he's calling Sharia Gordon. And remember what Sharia Gordon told you that phone call was. I'm on my way, I'm picking you up. How does that tie in with the home confinement records, with the cell phone records? Is there any other explanation for that? Except that Mr. Okafor was out of the house during these times that are shown in the home confinement records, exactly when the murder happened, and exactly corroborated by the cell phone records, the towers that he's hitting off of. And of course, on this same chart, the same map, we have this call over here, right near the Marathon gas station, which is this little triangle over there. And he's making a call from this tower at 4:44 a.m. That's Mr. Okafor again, making that phone call. Tying in with the Marathon gas station video, showing him there at 4:45, his sister's car, that Malibu. How does all this happen? This is just coincidence? Does Mr. Mosley have any explanation for this? And then, of course, his cell phone record also.
Hang on, excuse me a second, Mr. Holmes. We have an objection?
Here's the phone call at 4:44 a.m. Right about the time he's at the, and very close to the Marathon gas station, right before he gets there. Again, tying in with all the other records, with the home confinement records, and with his own cell phone records. And then, of course, we have him over here by the abandoned house and by the crime scene, and of course, exactly at the crime scene, the cell tower covering the crime scene, 503 Bernardino Drive, 5:05, 5:25 a.m. Is there any other explanation for this, except that that was Mr. Okafor, of course? It's his phone. How do we know it's his phone? We have all this evidence that it is his phone. We have Meg Hughes, the home confinement officer, who said she called him on that phone number many times. We know it's his phone. He signed. Here's a sign-in sheet, a weekly schedule. Remember Meg Hughes told you about the weekly schedules that are filled out. Here's his cell phone number. This is, and he signs it. Bessman Okafor signs it. This is July 12th. That's his phone. Here's the next one, another one, July 23rd. I'll get the hang of this eventually. Again, July 23rd, he signs it. There's his phone number, 407-221-7378. And here's another one. These are just samples of this. August, again, 221-7378. Signed by Bessman Okafor, August 28th, 2012. This has always been his phone. Meg Hughes told you that she called him on this phone a number of times. He always answered. She also told you she in fact called him at about 3 o'clock the next afternoon on September 10th. Remember, he signed in on the sign-in sheet. This is the September 10th, 2012 sign-in sheet. There's his name down at the bottom. She goes out to the waiting room. He's not there. She again called him on his cell phone. She gave you his phone, her phone number that she called him on. You can check the phone records yourself, by the way, if you want to do this. Called him on that number, and this is 3 o'clock the same day as the murder. This is maybe, what, about 9-10 hours after the murder. She called him with that phone number, and they're on the phone records. So he's got his phone several hours after the murder. He always had his phone every time she called him. He signed all these sign-in sheets, several dates, showing that that's his phone. And we also know, of course, from Antoine McLaren that that's his phone, his own friend, who just several hours before the murder, the same night as the murder, all those text messages to Antoine McLaren. This is just the same night as the murder. All these messages I need you to slide over here. Can't text it about my case. Clearly that's Mr. Okafor with this same phone. And you heard testimony from Antoine McLaren, his own friend, who says that he does go over there because Mr. Okafor wants him to get something. He goes over there, and Okafor tells him what it's about. I can't let the witnesses show up. So clearly, this is his phone. This is the phone that he uses all the time. There's no testimony that anyone else ever used the phone. So he's got the phone the night of the murder. He's got the phone right after the murder. Of course, he has the phone during the murder. In addition to, we have direct testimony from both Sharia Gordon and Nestle Cicerone that they both called him. They both spoke to him on the phone during the murder, 5 to 5:30 that morning. They both testified that, and that is also corroborated by the phone records. So how did this happen? And that ties in with the home confinement records. And then on top of that, we have Detective Michael, who testified. He examined the exact phone. That phone was found in Mr. Okafor's house when he was arrested. And of course, we know that Mr. Okafor deleted the text messages right before the police got there. Detective Michael told you about that, because he didn't like these damaging phone records. And while I'm talking about the I'll get back to it. While I'm talking, I'm sorry, really. While I'm talking about the text messages, there are also text messages to his brother Dory. This was about 2 weeks before the murder. Again, with that same phone, where Mr. Okafor is asking, did you get that? Well, he said he's going to be on his way at 8:30, says Dory. Cool. The next thing Dory says, it's here, with a full clip. And the next thing that Mr. Okafor says, they say all the witnesses going to show up. Damn, who told you? My lawyer. Again, Mr. Okafor. Clearly, obviously he wants to delete these phone messages, but these text messages show he is very concerned about the witnesses show up. He wants a gun. He wants a hoodie and gloves. This is all his phone. This all ties in with the cell phone records, the home confinement records. In addition, Detective Michael told you he examined the exact phone. He's able to determine from the phone itself that this is Mr. Okafor's phone, and he's the one that uses it. He told you that Facebook profile was looked at a number of times. The only Facebook profile that was looked at was Bessman Okafor. There were only selfies on the phone that are Bessman Okafor. There are voicemails still on the phone to Bessman Okafor. And Bessman Okafor is doing an internet search that very night. How do you get rid of gunshot residue? What's that all about? You know what that's all about. Because he's about to commit a murder, and he's worried about gunshot residue. And we also have, from Detective Michael, examining the phone. Remember he talked about the MAC addresses? That you can tell that the phone has a memory of 20 MAC addresses there. Showing Wi-Fi hotspots, I guess. And it only has a memory for 20. And this phone was recovered on the evening of September 10th. So these are not going to go back very far. It's not going to be from years ago, or months ago, or weeks ago. We know that Mr. Okafor is carrying that phone around with him that day because he use at 3 o'clock. So he's out and about all day long, sitting off Wi-Fi hotspots, I guess. And as you know, it doesn't hold more than 20. And what Wi-Fi hotspots are still in his phone? At the house, at 503 Bernardino Drive, Mr. Okafor's phone. This is devastating evidence. This is overwhelming evidence that Mr. Okafor was there. In addition to the direct evidence from Nestle Cicerone and Sharia Gordon, let me talk about them a little bit. As Mr. Williams told you, you should consider testimony of accomplices with caution. You should do that. Because they might have a motive to lie. And you should consider if it's corroborated by something else, then it's believable. If it's just something that an accomplice says, maybe it's not. Maybe it's not convincing. Mr. Mosley talked about the plea and sentencing agreements with these people, and he suggests, oh, they would lie, they would say anything at all, they would just lie to save themselves. Well, let's look a little bit at these plea and sentencing agreements. I know they've been entered into evidence. Let's look at them a little bit. Here's the one for Sharia Gordon. And it says, in paragraph 1, she's charged, here's what she's charged with. She's represented by attorney. Paragraph 3, she will testify truthfully in court on the date of her plea, and she will testify truthfully at any other times about this case. Paragraph 4, she agrees to testify truthfully in any future trials, hearings, whatever. She agrees not to feign amnesia or anything like that. And she will not attempt to protect anybody or falsely accuse anybody. Paragraph 5, feigning amnesia, refusing to testify will be, or not telling the truth will be a violation of the plea agreement. Paragraph 6, she will agree to undergo polygraph examinations if requested by the court. She has this hanging over her head, that the court can request her to take a polygraph examination to determine whether she's telling the truth. And although polygraph examinations are not normally admissible in court, she agrees it will be admissible against her to determine whether she's testifying truthfully. Is this somebody who's going to lie? And it goes on to say, she'll enter a plea of guilty. The state won't file additional charges. She'll be sentenced after everything's all over, after she's completed testifying in whatever trials there might be. And at that point, she will be sentenced. Paragraph 8 talks about what the sentence will be. The sentence will be determined by the judge, by Judge Kest, not by me, by Judge Kest. And the court the agreement says the court shall take her cooperation and truthful testimony into account, describes what the maximum period of incarceration can be, which for her is 25 years in prison. She can also be put on probation for the rest of her life on top of the 25 years. And the court will determine what the sentence is based on her truthful testimony, based on all the facts of the case. I don't know what the sentence will be. I don't know if Judge Kest knows what the sentence will be. He will decide what the sentence will be. Then it goes on to talk about that if she fails to abide by the terms of the agreement, specifically if she is found to have lied, all kinds of terrible things can happen to her. The statements she's made already are admissible against her. The state can withdraw from that plea agreement and go back and charge her with murder. the court can just accept her plea and not agree, not go along with this plea deal, and can sentence her to life in prison. That's what she has hanging over her head. If she lies, if she were to lie in court, that's what would happen to her. She could be sentenced to life in prison. What is her motivation? To tell the truth or to lie? And why would she lie against Mr. Okafor? The father of her child, the father of her unborn child at the time this happened. I'm sure we can all understand why she lied then. To protect him. To say she was his alibi was to protect him. And that's understandable. Why would she lie now? If this was somebody else that did this, somebody else that drove her to the Marathon gas station and picked her up right after Mr. Okafor called her, some other person somehow came and picked her up. Some other person drove her out to the abandoned house. Some other person got out of the Malibu and got into the Impala, which then drove to the house. And she's protecting this other person and accusing Mr. Okafor. Why? The plea agreement for Mr. Cicerone is exactly the same. It just has a different term. Instead of her facing, she's facing a maximum of 25 years if she tells the truth. Mr. Cicerone is facing a maximum of 15 years if he tells the truth. What motivation would he have to lie, to accuse Mr. Okafor of something when it was really somebody else? We know Cicerone was in a separate car. He was in Tony Nelson's Ford Taurus. We saw the Ford Taurus at the Marathon gas station. We saw the Ford Taurus at the red light panel. It was one of the 3 white cars. That's the car he was driving. He was not in the Impala that we saw on the neighbor's surveillance video driving up to the Bernardino address at 506 and coming back from there at 524. He was not in that car. He was in the car that you can see the little blinking lights out by the park. There were 3 cars there. Cicerone, we know, was in the Ford Taurus. It wouldn't make any sense otherwise. Who else was driving that Ford Taurus? Cicerone is lying to protect some other person? It makes no sense. He's got the same plea agreement. We just went over. I invite you to study these plea agreements, look at them yourself. And of course, all this evidence is corroborated in a number of different ways. Mr. Mosley admitted that Mr. Godfrey and Mr. Wallace were 2 of the people that went into the house. We know there were 3 of them. We know from Brianna and Remington about the 3 people that were there. So Mosley admits we got it right as to Wallace and Godfrey. Somehow we got it wrong as to Okafor. There's much more evidence against Mr. Okafor. Cicerone and Sharia Gordon were telling the truth about Wallace and Godfrey and somehow are lying about Okafor. And there's the home confinement record, the phone record, the actual evidence in the phone itself, the text messages, everything else. It makes no sense. Mr. Mosley suggested, well, Mr. Okafor's never done anything violent before, at least Cicerone, his friend, didn't know about anything violent before. What about the home invasion robbery? What about going into a house and getting everybody down at the floor at gunpoint? Let me talk to you a bit about the jury instructions. This is important. I know nobody's talked to you about that yet, and up until this point, nobody expects you to know anything about the law. In a few minutes, the judge will instruct you on the law. And thank you. And actually, And I know this can be a bit confusing if you just hear it for the first time, so let me go through it with you. The judge has told us what the instructions are going to be. As soon as I stop talking, he's going to read these instructions to you. You're going to get your own copy. Everybody, I think, is going to get their own copy. Let me just go through it a little bit because it's important. It's going to start talking about just what homicide is. Homicide is killing another person. It will tell you that not every homicide is a crime. There's something called justifiable homicide, which is self-defense, basically. That doesn't apply here. We know that. There's something called excusable homicide, which could be an accident, something like that. That doesn't apply here. We know that. Then it goes into first-degree murder. What is first-degree murder? The judge will tell you there are two different ways somebody can commit first-degree murder. Either one is first-degree murder. The first method is premeditated murder. Mr. Williams spoke about this a little bit. Premeditated murder is killing somebody after consciously deciding to do so. It's like swatting that mosquito that's on your arm and I want to kill that mosquito. It's intentionally killing somebody after deciding to do it. It's not an accident. It's not something that went wrong. You intended to kill somebody. Clearly, this was a premeditated murder. There's no question. That the text messages, when the coffee when the witnesses show up, the only reason to go to this house and line everybody up at the door and shoot them all in the head is to kill them. To kill them so they don't show up for trial. Clearly, this is a premeditated murder. There's a second type of first-degree murder, which applies just as well. We don't really even have to get to the second one, but it's called felony murder. What is felony murder? Felony murder is while engaged in the commission of a burglary, somebody gets killed. So felony murder can be even an accident. Let's just change the facts, okay? I commit a burglary, I break into a house, the homeowner comes out to his bedroom or whatever, I have a gun, I turn around, and accidentally the gun goes off. Let's just assume those are the facts for a moment. Okay, so I commit a burglary, I break into his house, and the gun goes off by accident and I kill someone. Is that a premeditated murder? No, it's I didn't intend to kill anybody. That's absolutely true. Okay? But it is first-degree murder. It's called felony murder. In the course of committing felonies, like a burglary, I killed somebody. And for felony murder, it isn't even necessary to show that I intended to kill him. So either one of those things is first-degree murder. In this case, we clearly have both. We have a burglary, and Alex was killed during the course of the burglary, and he was killed on purpose. There'll be a little instruction then about burglary, because felony murder says during the course of a burglary, what is that? And the judge will instruct you on what a burglary is, and a burglary is kind of simple. It's entering a structure owned by somebody else with the intent to commit a crime. So if I break into a house with the intention to steal from the house, that's a burglary. I steal something or not. I broke in, I entered a structure that I had no right to be in with the intention to commit a crime. That's clearly what happened. This will go on to tell you you really don't even need to consider first felony murder if you've already found him guilty of premeditated murder, and either one is good enough. You don't have to decide both or either one of those is first degree. There's also this instruction, and this is actually repeated again because it's important, called the principal instruction. Let me talk to you about that because it is very important. It's really a complete answer. This principal instruction is a complete answer to the defense argument. Principal is like an accomplice, or a co-defendant, or co-conspirator, whatever word you want to use like that. The art of calling a principal. where two people together commit a crime. So let's say, speaking with burglary, for example, let's say that Mr. Williams and I want to break into a house. And we see that there's an open window and it's kind of high up and neither one of us can reach it by ourselves. And I decide to give Mr. Williams a boost to lift him up so he can climb in through the window to commit this murder. I never even go into the house. I'm standing outside and I just help Mr. Williams get into the house. This principal instruction says is I am also guilty of burglary. Both of us are guilty of burglary because we are principals in the crime. Here's what it says about principals. The defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit a crime. To be a principal, the defendant does not even have to be present when the crime is committed. So in that little example I just gave you, I commit a burglary, I never went into the house. Am I guilty of burglary? I'm standing outside. It was Mr. Williams that did it. Well, I'm guilty too. I helped him. I assisted him to commit this crime. And because of that, all of these people, all 5 of them, are guilty of felony murder. Nestle Cicero is guilty. Sharia Gordon is guilty. Donnell Godfrey is guilty. Emmanuel Wallace is guilty. Bessman Okafor is guilty. Even the ones who never had a gun, even the ones who didn't go into the house, even the ones who didn't shoot anybody, all 5 of them are guilty of this murder because they are all principals. They are all acting together. So I know Mr. Mosley's argument is, well, you know, maybe Okafor never went to the house. Maybe he was sitting out in the car by the park. Maybe somehow he switched cars with Nestle Cicero. Somehow Cicero.
Excuse me just a second, Mr. Alden. Legal basis? I'm sorry? Come on up. I'm having trouble understanding you. Objection is sustained. The last comment will be disregarded. Please proceed.
Let me rephrase that. Mosley didn't argue that. Even if Mr. Okafor did not go into the house, even if he is not the one that fired the shot, again, there's all this evidence that he is the one that fired the shots. But even if he didn't, even if he was standing next to the actual shooter, and the actual shooter was Godfrey or Wallace, even if all he did was set this up, even if all he did was drive, as a lookout, like Cicero and Sharia Gordon were, he is still guilty of felony murder. And that's a complete answer to the defense argument in this case. All 5 of them are guilty of felony murder. They all acted together. It's not required for you to decide who the shooter was in this case. It is not necessary. We submit to you the evidence is overwhelming that the shooter was Bessman Okafor. That is not something you need to even decide. If this were a trial against Donnell Godfrey or against Emmanuel Wallace, we would be asking you to return a verdict of guilty of first-degree murder to death, even though we would tell you they're not the shooters. If somehow Nestle Cicero didn't plead guilty and decided to go to trial, we would argue that he was guilty of first-degree murder because he assisted by being a lookout. Same thing with Sharia Gordon. They assisted in maybe they didn't even know it was a murder. They thought it was a burglary. That would be enough. They would be then principals in felony murder. Participating in a burglary, and somebody got shot even if they didn't intend the person to get shot. All of them are guilty of first-degree murder. It's not necessary for you to determine that Bessman Okafor was the shooter, although there is overwhelming evidence that he was the shooter. Mr. Williams went through that in terms of the Glock was not the gun that fired the shot. Nobody stuck around and flipped up to take cartridge cases. You learned that. It was not the Glock that was the murder weapon. It was not the rifle that was the murder weapon. If Godfrey had the Glock, we know that Wallace had the rifle. By a process of elimination, it was the person that got Brianna out of her room, and that was Mr. Okafor, who was the shooter. And as Mr. Williams told you, the only way anyone would know that Remington was not there the first time would be if that person was there the first time, that first home invasion that occurred on date night. Norman Bernard was in jail the whole time, so it wasn't him. The only way anybody would be able to say who's the naked guy, the naked guy is Remington Campos, who wasn't there the first time. It's the only way anybody would have any reason to say that. Who's the naked guy? So we recognize that this guy wasn't there. There were the other two. The only one who was there the first time, wasn't in jail, was Bessman Okafor. Let me go on with the jury instructions. There's a little instruction here that basically tells you that you don't even have to consider felony murder if you find him guilty of first-degree murder. We discussed that. Then it goes on to the other counts. And there's attempted murder as to both Brianna and Remington Campos. And this is kind of clear. It's basically trying to kill somebody where you don't. Same thing applies. Tried to kill both Brianna and Remington. That was the intent, obviously, to lay them down before to prevent them from testifying. I won't really go into that much more, but clearly this was an attempted murder as to both Brianna and Remington. There's also an instruction, count 4 is burglary. Burglary we've already talked about a little bit. It's not entering the structure with the intent to commit a crime. Clearly that's what happened here. They kicked in the door with the intent to kill people. That's what this is all about. So that's a burglary. The second they kicked in the door and walked inside, they did the burglary. Nothing else happened. And there will be some enhancements to burglary. One is committing an assault or battery in the structure. An assault or battery is just basically scaring somebody or touching somebody against their will inside the house. That's an assault or it's a battery. There's another enhancement about using a firearm, which clearly happens. So all of these people are guilty of burglary as well. There's the principal instruction again. It applies to every charge here. So again, Mr. Cicero and Miss Julie Gordon are both guilty of burglary as lookouts, even though they didn't actually enter the house because they assisted. There are also lesser included offenses. It's conceivable in a case that somebody might not be guilty of the main charge. If one of the elements wasn't met. Somebody could be guilty of a lesser charge, none of the lesser. But the judge will also tell you, if you find a person guilty of the main charge, you have to look at the lesser included offenses. In a particular case, it would be possible, that you committed some crime, but not the main crime charge, some lesser crime. That's not the case here. But the judge will instruct you on what lesser included offenses are. There's second-degree murder, there's manslaughter. None of those apply here. It's attempted second-degree murder. But again, you don't really need to even look at those. There's also an instruction about weighing the evidence, how you evaluate witnesses' testimony.
What's the legal objection? He's not reading the instruction. He's simply saying there's going to be an instruction on weighing the evidence. Overruled.
We'll take a look at that. I won't belabor the point. And that's basically it, ladies and gentlemen. Again, I would submit to you the evidence is overwhelming that Bessman Okafor was at that house. You know, they only find records, the cell tower evidence, the evidence in the cell phone itself, the text messages, the witnesses' statements, on and on and on. Bessman Okafor was one of the three people who went into that house to commit this murder, and in fact, it's not just something you decide, but that Bessman Okafor was the person who pulled the trigger, shot Brianna Campos, who shot and killed Remington Campos, and who shot twice and did kill Alex Zaldivar. We ask you to return the only wrong verdict in this case. She's guilty as charged.
Thank you. Folks, it's 1:40 and you are well past your lunch hour. Your lunch is in there. I have some instructions I want to give you, but I need you awake and attentive and not your stomachs growling in the middle of it. So I'm going to send you back to eat first and then bring you back in here. Extremely important at this point. You have heard all of the evidence, all of the testimony. You have heard the arguments of the attorneys, the closing arguments, but you have not heard the law in this matter, and that's critical. So I know you're going to be back eating lunch together. Talk about anything you want, but not this case. We're not going to rush you on eating. I'm going to have the deputy check with you in about 30 minutes to see if you're done. If you're not done, don't feel like you have to swallow faster. Just let the deputy know you have a few more minutes. When everybody's done, we'll bring you back in, and to give you some time frame, it will probably take me about 20 minutes to give you the law. Once we do that, we're going to turn the case over to you in this matter. So you're a short ways from having this case. Go back and eat your lunch. And rest a little bit. Again, we'll check with you in about 30 minutes. If you need more time, simply let Jeff know that, okay? Thank you all. Please do not discuss the case. Leave your pads on your chairs.
All right, very good.
Folks, their lunch is in there already. We're going to give them about 30 minutes, and then I'll check with them. So I'd ask everybody to be back in 30 minutes who's involved in the case, if you would, please. And we'll give our court reporter and certainly clerk an opportunity to get something to eat in this matter. All right. Thank you. We'll be in recess. What time is it? About 10 after.
Is she going to let JT